We're back with breaking news out of Virginia, where Attorney General Pam Bondi just confirmed the FBI executed a search warrant at the home of a Washington Post journalist. Bondi says the journalist was, quote, obtaining and reporting classified and illegally leaked information from the Pentagon contractor, who she adds is currently behind bars. Hannah Natanson, who covers the federal workforce, was at her home when this search was executed. The Post says she has been part of the publication's most high-profile and sensitive coverage during the first year of the second Trump administration. Let's bring in MS Now legal analyst, former Manhattan Assistant District Attorney Catherine Christian. Lisa, what do you make of Bondi's comments on this investigation, this search warrant? Just how unusual is all of this?
Well, it's incredibly unusual. Let's start with the fact that in April of last year, Pam Bondi rescinded a Department of Justice policy that was promulgated by then Attorney General Merrick Garland during the Biden administration. And in place of that policy, she put in a new policy to make it easier for the Department of Justice to conduct searches of journalists' home and offices when the Department of Justice is conducting a leak investigation. She essentially said that this Department of Justice would not tolerate the leaks of classified information, and therefore
the deadline passed quietly, but the silence afterward was deafening. When a law commands disclosure and the government responds with less than 1%, that is not delay, that is defiance. And when that defiance comes from the Attorney General of the United States, it stops being a bureaucratic failure and starts looking like a constitutional stress test. What happened here is not complicated, and that simplicity is precisely what makes it dangerous. Congress passed a statute demanding the release of all unclassified materials related to Jeffrey Epstein, his network, and the machinery that protected him. The language was blunt. The timeline was explicit. The obligation was mandatory. There was no wiggle room, no discretionary escape hatch, no invitation to slow walk the truth. The law was signed. The clock started. The deadline expired. And the Justice Department, under Pam Bondi, produced a symbolic gesture masquerading as compliance. Less than 1%, heavily redacted, critical reporting requirements ignored. That is not an interpretation dispute. That is a refusal to execute the law. And the refusal matters because the subject matter is radioactive. Epstein was not just a criminal, he was a node, a connector, a mirror held up to power, wealth, and impunity. The files tied to him are not ordinary records. They are a map of who had access, who looked away, who intervened, and who benefited from silence. This is where the story shifts from scandal to structure, because when the Attorney General blocks disclosure mandated by statute, the question is no longer what is being hidden. The question becomes who is being protected and by what means. Strip away the noise and look at the mechanics. The Justice Department missed a clear statutory deadline. It failed to deliver the volume of material required. It buried what little it released under aggressive redactions. It skipped required updates to Congress. Every safeguard designed to ensure transparency was either ignored or neutralized. That pattern matters because it mirrors something we have seen before: delay, obfuscation, partial compliance, and then appeals to process once accountability closes in. A federal judge noticed. Judge Richard Burman did not issue a press release or deliver a speech. He did something more dangerous to a stonewalling executive branch. He demanded specifics. He ordered the department to explain, on the record, exactly what Epstein-related materials it possesses and why those materials remain withheld. That order is not procedural housekeeping. It is the judicial equivalent of flipping on the lights. Because once you are forced to inventory what you have, you lose the ability to pretend it does not exist. Once you are required to justify secrecy in detail, you lose the protection of vague invocations of privacy or process. This is how courts build the foundation for contempt. They do not leap, they document, they create a record, and Judge Burman is constructing one brick by brick. At the same time, Congress is moving on a parallel track, and this is where the story becomes genuinely volatile. Lawmakers from opposite ends of the ideological spectrum, including the very authors of the statute, are preparing to invoke inherent contempt. This is not symbolic outrage. This is a constitutional weapon that predates modern partisanship and bypasses the executive branch entirely. It allows Congress to punish obstruction of its authority directly, without waiting for prosecutors who answer to the very official under scrutiny. Inherent contempt has not been used in nearly a century for a reason. It is blunt, it is confrontational, and it exposes the raw architecture of checks and balances that polite governance prefers to keep hidden. Reviving it against a sitting attorney general is not escalation for show. It is an admission that normal enforcement mechanisms have failed. The proposed structure is simple and brutal. Daily fines, imposed personally, accruing until compliance occurs. No grand speeches, no endless litigation. Just a meter that keeps running as long as the law is ignored. This is Congress saying that patience has expired. The bipartisan nature of this move is critical. This is not a partisan ambush. The lawmakers driving it wrote the statute together. They are not defending a party. They are defending the law itself. When the authors of a statute accuse the executive branch of breaking it, the usual defenses collapse. You cannot argue misunderstanding. You cannot claim ambiguity. The intent is known because it is theirs. Now add the political context, because ignoring it would be dishonest. Pam Bondi is not a neutral bureaucrat. She is a political actor operating inside an administration built around loyalty and transactional protection. And the Epstein files sit at the intersection of money, power, and proximity to Donald Trump. Bondi has repeatedly deflected questions about whether Trump's name appears in the materials. The administration promised transparency. The administration delivered opacity. That gap is not accidental. It is familiar. We have seen this movie in the Russia investigation, in Ukraine, in January 6, in classified documents stored like souvenirs. Promise cooperation, deliver obstruction, invoke process, run out the clock. The difference here is that the law was designed to prevent exactly that strategy, and the strategy is being deployed anyway. This is why the term cover-up is no longer hyperbole. When the Senate Majority Leader uses it, he is not speculating. He is describing behavior. A cover-up is not defined by what is ultimately hidden. It is defined by the actions taken to prevent disclosure. Missed deadlines, token releases, excessive redactions, stonewalling oversight. Those are the fingerprints of concealment. The Justice Department insists this is about protecting victims. That argument collapses under scrutiny. Survivor privacy can be safeguarded without suppressing entire categories of documents. Redaction is a scalpel, not a blackout curtain. When nearly everything disappears, privacy becomes a pretext, not a principle. This is where the constitutional implications sharpen. The Attorney General does not have the authority to nullify a statute through inaction. That power belongs to courts and legislatures, not to a single executive official. When the executive branch decides which laws it will obey based on political convenience, the rule of law becomes conditional, and conditional law is the seat of authoritarianism. Zoom out and the pattern becomes unmistakable. This administration treats accountability as optional and transparency as a threat. It weaponizes delay. It relies on fatigue. It assumes institutions will blink before it does. The Epstein files are not an anomaly. They are a stress point revealing how far this normalization of defiance has gone. The judicial and congressional pressures now converging are not guaranteed to succeed. They are guaranteed only to clarify the stakes. Either the Attorney General complies and the public learns what has been hidden, or she refuses and the constitutional machinery grinds forward into territory this country has not visited in generations. If Judge Burman's order is met with evasion, the court has options: contempt, sanctions, targeted orders stripping discretion. If Congress follows through on inherent contempt, it will force a confrontation that tests whether legislative authority still has teeth. These are not abstract possibilities. They are live wires. The psychological dimension matters too. Power that expects impunity reacts poorly to constraint. The more pressure applied, the more erratic the defenses become. That is when mistakes happen. That is when narratives fracture. That is when the truth leaks through seams that were supposed to hold. The Epstein files represent more than a catalog of crimes. They represent proof of how a system responds when its own reflection is ugly. Does it confront it, or does it shatter the mirror? Right now, the Justice Department is reaching for the hammer. And here is the unavoidable reality. Donald Trump signed the law demanding disclosure. His administration is now in violation of it. Either that signature was a lie meant to placate public outrage, or his Attorney General is openly defying a statute his White House endorsed. Both possibilities indict the same culture of bad faith. This moment will be remembered not for the procedural filings, but for the choice it forces. Compliance means surrendering control over a narrative that has been managed for years. Defiance means daring the other branches to enforce their authority. There is no third path. We are watching the separation of powers stop being a theory and start being a confrontation. And those moments are rare because they are dangerous. They expose whether democratic guardrails still function when the people inside the system would rather they didn't. If this pressure fails, the message to future administrations will be unmistakable. Ignore Congress, stall the courts, and wait it out. If it succeeds, it will stand as proof that even in an era of corrosion, the Constitution can still bite back. This is not about curiosity or gossip. It is about whether laws apply equally when the truth threatens the powerful. The Epstein files are the test case, but the precedent will echo far beyond them. Pay attention to what happens next. Watch the filings. Watch the votes. Watch the excuses change shape. Because when accountability finally arrives, it never announces itself politely. And if you want to stay ahead of that moment, stay engaged, stay alert, and do not look away when the system shows you exactly how it works under pressure.